Good morning, everyone. What a bright and sunny morning it is here today in London, on the eve of our second lockdown. Yeah, this seems like yesterday that we went into the first one. Cannot help thinking this is God's way of reminding us how lucky we are to have our freedoms. Um, anyway, welcome everyone to Macalvins' November 2020 webinar. I'm joined this morning with our guest speaker, Shandeep Shah, Managing Director of Balance Consultancy, and Keo Doshi, who has been on this panel a number of times before, Associate Director Tax at Macalvins. We'll be discussing how to preserve and subsequently bequeath your wealth for future generations and beneficiaries, or bluntly, death and taxes. Hopefully they'll make it a little bit more positive than that. We'll have time for Q&A at the end, but feel free to raise any questions as we go through the discussions via the Q&A tab at the bottom of your screen somewhere there. And we'll try to answer these on the fly. If not, we'll deal with them at the end at the Q&A point. Without further delay, I'll hand over to Keo. Keo, thank you.
Thank you, Tariq. Thank you, everybody, for joining us. And I hope you will have some interesting points and takeaways at the end of the webinar. It's an interesting topic in the current climate. It's never been more important to look at things like inheritance tax and will. So it's quite topical, and we hope that you all find some value in the webinar. The part I will deal with is inheritance tax. Our guest speaker, Shandeep, will deal with the will side in the second part of the webinar. The interesting comment there we thought will be a good point to start with. Some people have indeed called inheritance tax a voluntary tax, or a tax that only people who can't afford good advice pay. And as the quote there from an MP suggests so. But when you take a step back and look at inheritance tax, and when I speak to clients and families about it, it's a very hard sell to swallow this bitter pill of inheritance tax. You worked all your life, you paid income tax, capital gains tax, stamp duties, VAT, whatnot, to help the economy and help live in this civilized society and pay your fair share. And in this part of the world, Southeast or London, with the property prices there, they are, even if you've not been too successful, let's put it that way, it is likely that you will be caught in the inheritance tax net, purely and mainly because of the principal private residence. So this tax that was meant for really the ultra wealthy when it was brought in now applies to a lot wider tax base. And main question really is it's a tax that you will never pay in your lifetime. So it's important you think about it from the beneficiary's point of view. And as the slide there talks about, who really pays the inheritance tax? It's the family that will have to pay the inheritance tax, the beneficiaries who are left after you. There are various, as we said in the previous slide, if you plan properly, there is quite a positive outcome possible where your estate will not suffer any inheritance tax. Today, the idea is obviously inheritance tax. We can have a 2-hour webinar and it will still not be enough to cover every possible allowance, relief, planning points. The idea today is to touch upon something which is very topical and recent changes, which is around the nil rate ban, or as we call it, the residential nil rate ban, or some people call it the additional nil rate ban. But as the slide there talks about, one point to remember is between married couples, on first death, there is no inheritance tax. Any assets transferred to the surviving spouse is free of inheritance tax. Then the nil rate bans come in. You all know that every individual in the UK has a nil rate band of £325,000. There's this transferable nil rate band, and we'll talk about that a little as well, between husband and wife, between spouses. If it's not used on first death, quite a generous relief available to carry it forward on second death. So as a couple, you could have 2 nil rate bands available. And the new additional nil rate band, has been staggered in terms of how it's been brought up, but now we are at its maximum value with effect from this tax year, 2021. The full £175,000 is now available. So on an individual basis, if you qualify for both the reliefs, the first one is very much there without any qualification criteria. There is a small print that comes with the residential nil rate band. You need to tick a few boxes to be able to qualify for that. But if you do qualify, you could have an individual nil rate band of £500,000, which gives, if we move to the next slide, we can see how uh, the total available allowance as a couple you will have will be of £1,000,000. So 3 to 5, and 2 175 get you to £1,000,000. Broadly speaking, anything over and above that is taxable at 40%. That's inheritance tax. And I was talking
Yeah,
to
yeah, if you don't mind me interrupting you for a second, but I was just thinking, I mean, obviously we were looking very much at these nil rate bands and the residence nil rate band in particular, but what about people that own businesses? Um,
a very, very important point. Thank you, Tariq. It's a very important relief in the RHT world that we have, and it's topical as well. What you're referring there is the business property relief, which is quite relevant in our client base, owner-managed businesses. So the premise of that is if you're passing down trading businesses, that qualifies for 100% relief, BPR, business property relief. Why it's topical? The Office of Tax Simplification, the government advisors, if you like, non-statutory, they are not binding advisors, have come up with 11-point suggestions on simplification, if you like to call it. But the suggestion there is, at the moment, you have best of both the worlds. When assets, business assets, are passed down, you get the base cost uplift for capital gains tax purposes, and it's free of inheritance tax. Whereas what is now being suggested, there is no suggestion to make it subject to inheritance tax. However, there is a suggestion that the base cost uplift should not pass, i.e., the beneficiaries will inherit the base cost of the previous generation, which means all the pregnant gains which wash out at the moment on death will not happen. And with the pandemic and the government finances where they are, and Rishi has already announced a review of CGT regime. It's considered in the professional circles that this measure, in fullness of time, will come through. So that's a space to watch really for owner managed businesses where you're thinking of planning of handing down business assets, something to have a review and see that you are in the best position possible. So getting back to what we were talking about, inheritance tax as a general tax cost, you're looking at a 40% tax rate. And talking about the couple I was speaking to last week, husband and wife, 2 kids, and I said it a bit jokingly, but actually that's quite true. If enough or good IHT planning is not put in place, assets over the nil rate bands, Treasury becomes the best child. They get 40%, and the children inherit 30% each. So when you put it that way, it brings home the point of how important this planning really is. And we can talk about various reasons why people put it off. I'm sure Sandeep will know about that more than me in terms of wills and doing that planning. Uh, Not a very exciting topic. I get that, but when you really focus it that way, that the treasury will get 40% of your wealth, and your kids will only get 30% each, or anybody in your beneficiary list will inherit less than them. It reminds us all how important this piece of planning should be. If we move to the next slide, few health warnings there about not to make assumptions about nil rate bands. One important one is unmarried couples don't benefit from the most generous exemption, which is the spousal exemption. Any assets transferred on first death between Married couples is completely free of inheritance tax, which is not the case for unmarried couples. Uh, the nil rate bands and the residential nil rate bands we've been talking about in the previous slide is again not available for an unmarried partner. Uh, and if your circumstances are such that you want to leave the main residence to an unmarried partner with the understanding that on the second death it passes to your children, careful planning is required that you don't miss out on the residential nil rate band. Next slide, please. This is a very important slide in the RHT presentation today, because the number of clients I've spoken to and everybody has just assumed that £1 million allowance is available to them against their estate, which is not the case. The residential nil rate band has got a tapering mechanism built into it. As it says on the slide there, if your total estate is above the 2 million threshold, there's a tapering that kicks in. For every £2 above the threshold, your additional nil rate band or your residential nil rate band is reduced by £1. So based on the current allowance numbers, if your total estate as an individual is about 2.35 million, your additional nil rate band is reduced to zero. So effectively, as a couple, if you both happen to be in that situation and your estate is over 2.7 million, your nil rate band is not £1 million, or your allowance is not £1 million. It actually reduces down to the basic £650,000, and that creates this what we call an effective potential 60% inheritance tax rate trap, which really is painful and easily avoidable with correct planning. But be very mindful of this trap. Even couples where they've got the assets not split in the right proportion between them could create problems in terms of passing the additional nil rate band available for second death. We will see this in some illustration in the following slide, and what planning options are available just to illustrate this point. So we've got here a hypothetical case. James has never been married. He's got an estate worth 2.35 million. The point about never married is to say about his transferable nil rate bands are not there. We're only looking at his nil rate band. He's got a daughter who...
Okay, apologies. Can I interrupt you for a second? Sorry, just a couple of the guests are having trouble hearing you. Sorry.
Okay.
I'm asking, can you come a bit closer to the mic?
Thank you, Tariq.
Thanks.
I'll try and be a bit louder as well. I hope this is better.
That's good.
James's daughter is the sole beneficiary on his death. Unfortunately, we have to ask James to pass away in 2021 for the benefit of this illustration. On his estate worth 2.35 million, if nothing else was done, the tapering will kick in, giving an allowance of only £325,000 rather than the additional £175,000. So the IHT that his daughter will suffer is £810,000. Now, what is the solution here? And it is quite possible to mitigate some of that tax cost, and we will see in the slide next as to how we can do something of planning, and it's quite, as I said, unfortunately topical in the situation we find ourselves in a pandemic. If he made a deathbed gift to his daughter of £350,000, though it will be a failed pet potentially exempt transfer, we are not saving inheritance tax fully on that. It is still subject, the estate value subject to inheritance tax will still be 2.35 million as it was. But the effect of the gift is such that for the tapering purposes, because it's a pet, he's already gifted that out, the estate value for tapering purposes is 2 million, which gives him an additional allowance of £175,000. So his daughter would save £70,000 just by James making a deathbed gift of £350,000. So quite a big chunk of saving there, £70,000 when you think of it, by doing not great deal of planning. This is all last minute planning. Ideally, we will like to do uh, much more advanced planning, and we will see in a little bit of a different iteration of this illustration in the next slide as to how even further tax savings could have been made with a bit of forward planning. So similar situation, we're looking at not too different scenario. David, again, he's never been married, estate worth very similar to James's. Son in this case is the sole beneficiary on death in 2021, i.e. this tax year. Residential nil rate band is zero, inheritance tax is 810,000, no different to James's case. Here we are assuming rather than a deathbed gift, what if David had made a gift of £350,000 to his son 7 years ago? We all know that, I'm sure, about this 7-year rule where gifts made before a certain period falls outside your estate. There's a staggered discounted rate that is available for these pets after a 2-year clock. So 80%, 60%, 40%, 20%. But in this case, because the 7-year period has passed, the entire £350,000 would fall outside of David's estate. And IHT bill will be only 600,000, giving a inheritance tax saving of £210,000 on a potential gift of £350,000. I mean, the numbers, I know, 60% savings just because David gifted £350,000 7 years ago to his son, who is inheriting it anyways, 100% of the estate. So the point, really, the takeaway point here is try and make sure your affairs are structured in a way where you maximize your two nil rate band allowances, the 325,000 and the additional nil rate band of £175,000. Not doing that could cost you 60% in inheritance tax, not just 40%. Not that 40% is a low rate of tax, but as this example illustrates, saving of £210,000 is possible. If we move to the next slide, please. Yeah, I think so. We've covered that. Combined estate on second death is what one should be looking at. But even in your lifetime, splitting between the father and the mother, if that's the case here, would yield better results. There is a health warning there as well, where, and again, Shandip will cover this in the wills, because these are the kind of questions you will have to consider as a family, whether the kids are minor and how do you want to leave the asset to them, which is the main family home. If you put an age-related condition in your will to qualify for the additional nil rate band, which is only available on you passing the main residence down to your descendants, it will not be eligible if they have not hit that age threshold. So again, careful planning is needed. Again, mortgages related to the main residence would play a part in the maximization of your additional nil rate band for your main residence as well. Trying to look at various other planning options. Obviously, if your estate is in the range of 3 million plus, probably the additional nil rate band will be compromised for you, but there are various other tools and planning opportunities available to look at inheritance tax. Some of them are listed there. One are not listed there and probably is not a good advice. In my training days, I was told one of the best inheritance tax planning advice was spend it. I don't think so. justified listing on there as a tax planning option. But on a serious note, use of trusts, lifetime gifts, business property relief still continues to be a very important and generous relief. But it's very, we have found in our experience, when we look at things in details, it's wrong to assume that your business qualifies. All the test criteria needs to be tested, and charitable gifts, if that's somewhere in your will planning, there's an IHT angle, effectiveness can be brought into that as well. But
Yeah, you mentioned mortgages, which I follow, but I suppose there's a practical aspect, not tax related, but if you've got a mortgaged property, somebody has to pay that mortgage, right?
yeah,
And typically mortgages are not transferable to beneficiaries of a will. And I don't know, Shandy, you may have some experience of this yourself as well in beneficiaries sort of coming into or benefiting from an estate. Maybe they've got a property passed to them worth $500,000, but it might have a £350,000 mortgage on it. So what are the practical aspects of addressing that? And is there any planning? Again, this is not tax related, but is there any planning that can be done ahead of that to help the beneficiaries? Because they could be almost lumbered with a problem.
from a tax perspective, what I was alluding there in the previous slide, Tariq, was you want to make sure that you've got enough equity in the main residence to maximize your additional nil rate band, because otherwise you'll be restricted to whatever is the equity left in the house. So if as a couple you want to maximize the £350,000 worth of additional nil rate band, you want to look at the mix of your assets in your estate to make sure you leave enough equity. Because as a general rule of thumb with inheritance tax planning, if the couple is elderly, you would say an inheritance tax is an issue because their estate is of a certain value. Uh, in the past, the advice had been don't try and pay off the mortgage from an inheritance tax perspective, because that will be deductible against the estate for inheritance tax purposes. But those clients need to review that they create enough equity in the main residence such that when passed down, you can maximize the use of the additional nil rate band. Uh, Sandeep, your view on how beneficiaries deal with the practicalities of it?
Yeah, very interesting question, Tariq. And I think there's two angles to this. Debt is always very good for inheritance tax planning. So having greater debt, obviously your net estate is lower. What we would always recommend is on mortgages, on particularly main residence, make sure there's enough or adequate life cover, which is written in trust. So it doesn't form part of your estate. It'll go straight to the beneficiary. They can use that to pay for the mortgage. But if no planning is done, then unfortunately you're at the mercy of the lender at that point, because they can then decide, okay, is this affordable, not affordable, whatever, for the recipient.
So very careful to get that sort of planning away if
Absolutely.
that is likely to be an issue down the road.
Potentially, yes. Yeah.
Okay, thank you.
Thanks, Tariq. Thanks, Sandeep. Just to wrap up the inheritance tax side of the presentation, really, with the key here is make sure you are structured, your affairs are structured in a way that all the possible allowances are maximized, reliefs are used to the maximum effect possible. But to do a lot of this planning, everything is based around taking effective action in your lifetime, doing the planning, and a lot of it is very much overlapping with making of a will. So just if we move to the last slide for this presentation, just to conclude how important it is to make a will, because that is really the catalyst which will uh, help you kickstart what your wishes are, where you want to go, how, and with an inheritance tax angle across it, from a planning perspective, how do you structure it such that your wishes are given effect to, but in a tax efficient manner. Maximizing it up to £1 million of allowances for the family, maximizing business property relief, all that is possible, uh, but planning is key, and really can't stress enough in the current climate how important this is.
Great, thank you, Kia. So I think if we go into the moving on, so we've dealt with the first certainty in life, that's taxes. Now on to the next one, and planning for the second certainty in life. So over to you, Shandeep. Thank you very much.
Thank you, Tariq, and Keyur, thank you for your talk as well. Very, very interesting, and it all sort of ties in very nicely. And thank you to Macalvins for the opportunity. So if we go on to the first slide, Joe. So initially, I'll start off with wills, and then thereafter, I'll move on to lasting powers of attorney. So next slide, Joe. Absolute certainty, as Tariq said, one day when we are born, one day we will pass away. There's no two ways about it. The only uncertainty about all of this is when it's going to happen. You can be anywhere in that journey, from when you're 100 years old to dying anywhere a lot younger than that. So, you know, it is a certainty. However, and next slide, Joe. It is so certain, yet 60% of the population actually plan or fail to plan for this eventuality. We know it's going to happen. We know all we don't know is the timing, but we are still afraid to plan for this eventuality. Okay, so why is that the case? Various reasons. You know, a lot of people don't want to talk about death, don't want to think about death. I've had many people who say, look, if we write something down about our death, that means we are going to die very soon, or we are going to die. It just doesn't make sense, because you will die. One day you will die. Okay. So what I'm actually alluding to is that the way to sort that eventuality out and that certainty out is to have a document to basically write your wishes and what you'd want to happen after death. Give direction to the people you're leaving behind. Okay. Next slide, Joe. So this document is called the will. In very simple terms, it's actually your wishes. What do you want to happen to everything you own? Your property, your investments, your money, your jewelry, your personal chattels, collections, that kind of stuff. What do you want to happen to all of that after you pass away? And this document is called the will, in very simple terms. You can make the will at any time from the age of 18. Okay, so typical key markers are when you purchase a first property, marriage, or when you've had your first child. And that's an absolute must. When you have your first child, there's a note in the will to do, or clause in the will to do with guardianship. Now, I'm just going to touch on that literally for a few seconds. If we don't have guardianship written down in an official legal document, and both the parents pass away before the child turns 18, the law in this country does very clearly state that the child, for their own protection, will be taken in by the social services and foster care until a court application is made by the nearest people. And they may not be the people who you would have originally wanted to take parental responsibility. So it's just a footnote regarding that last point. So next slide, Joe. What happens if you don't make a will? Okay, obviously stress for the loved ones, people you're leaving behind. They've got to pick up the pieces. Do they know what you own? Do they know where all your bank accounts are, where all your investments are, all of that kind of stuff? You've left a lot of uncertainty there. What were your wishes? The third point I'm going to come on to last, because that is really one of the most important, but I'll come on to last in a moment. Under the law of intestacy, your properties, your assets may well go into the hands of people you don't want it to go to, particularly if you're single, not married, you don't have any children, etc. It could go in a very different way under the law of intestacy. It could lengthen the probate process, okay, particularly if there are contentions, that kind of stuff. So coming back to the third point of feuds and infighting, this is what we are seeing a lot of in the last couple of years. Money is a very funny thing, and you've got solicitors out there who will fight cases where, on a no fee, no win basis, where they can put in a claim under the Inheritance and Protection Provisions Act. They can put in a case if you've got a legitimate right for claiming. I'm going through a few of those at the moment, and yeah, not a great spectacle, to be honest. And who earns out of all of this? The solicitors. So next slide, Joe. Okay, so before we go on to the nitty-gritty details of the will, a lot of people do think that if you don't have a will and you are married, automatically everything goes to the spouse. It is not the case. If you have a child or children, then basically there are certain rules of intestacy, which I'm not going to go into in detail, but the first 270 will go to the surviving spouse. The rest is then, in simple terms, split half-half. Now, do you really want a child to inherit at a very early age, or children at a very early age? Do you want to ensure your spouse doesn't have enough for the rest of their life? There's so many different things you need to think about. So absolute key, avoid intestacy. Intestacy is the word which is used when you've passed away without a will. So just bear with me 1 second. The light is just here. There you go. Sensor lights. Okay, so avoid intestacy at all costs. Avoid your estate being dictated by the government. So this is the rules of intestacy, and I'm going to skip that for now, but I've just said, first 270, and then thereafter it goes downwards according to the rules. Next slide, Joe.
Sandeep, just a quick question, if you don't mind.
Sure.
You were saying there about how dreadful and really one of the key point why somebody should have a will in place is not to end up in intestacy.
Yeah.
Situations where you've had a will, but events in life, some clients working with you, I've come across realizing that the old will is not valid, and though the client is under the impression that they have a will which was done 20-30 years ago, whatever, could still be subject to intestacy. And one example was probably a marriage, or do you want to just clarify that? I think.
Yeah, so I mean, if you're single, you have a will, but if you get married, on the date of marriage, that will becomes void. Okay, it's null and void. So effectively, you're going now under the rule of intestacy. If you've had a divorce and you haven't changed the will, again, there could be a real issue. Although the divorce partner, as long as it's divorce absolute, it's classed as the person has passed away or the beneficiary has passed away. But they could easily challenge, if they've not remarried, they can easily challenge that will to say, look, they did promise me, blah, blah, blah. 20 years down the line, you could have lost the will, that kind of stuff. So there is all sorts of issues. And I'll come on to it later on in the slides where, storage of the wills, that kind of stuff is really important to note. But yeah, your valid point, update and just review your wills every so often, 5-6 years, review your wills, make sure, is this actually what I want today? Have circumstances changed and you haven't changed the will? So yeah, very good question on that. Yeah. So what goes in a will? In simple terms, first and foremost, of course, the person who's writing the will is called the testator or female testatrix. People who will be handling the will, the executors, the trustees, so people will do the probate. If there's a trust in the will, they'll be managing the trust. You can have funeral wishes going in there. Like I said earlier, guardianship of the children, who will be the guardian. Any gifts you want to make prior to the next step, which is gifts to charities, gifts to relations, personal chattels, gifts, gifts of particular items, you know, your Rolex watches, your different properties. Those come before the next slide. So, okay, so basically after the gifts, you have what's known as the residue. Residue is then what's the balance of your estate. How is that going to be split? Now, there are two kinds of wills. We've got simple wills, which say me to you, you to me, then down to the children on second death. And we potentially could have a third layer, which is called the calamity, in the event the whole family passes away or the children have passed away before you. Nothing wrong with simple wills at all. You will still get what Kayur said of spousal exemption. And again, I'm assuming about marriage here, but you'll get the spousal exemption, you will get the nil rate ban, you'll get the residential nil rate ban. All of that will come into the simple will. However, simple is not adequate for every single client. Depending on the size of the estate, and particularly estates which are over 2.7 million, 2.5 million above, there is a great need for looking at trust-based wills, because what you're now doing is using the will to plan for the generation after. Okay, generation after you and the generation subsequent after that as well. So grandchildren, great-grandchildren, great-great-grandchildren. I'm not going to go into detail, but a will is a very good tool for generational planning, particularly large estates. And we do use trusts in many of those large estates. So what makes a will valid? First and foremost, you must be signing the will. The person who's written the will has to sign in front of two independent witnesses at that particular time as well, not remotely or not in different times. They have to be present at that same time. Of course, it goes without saying, making a will, you must have adequate mental capacity, you must have sound mind, you must know what you're giving away, i.e. your assets, etc. Now, it is said, yeah.
Apologies, can I interrupt for a second?
Sure.
So you mentioned obviously having the witnesses present when you signed the will.
Yeah.
So in these difficult times that we're faced with, going into a new lockdown tomorrow, have you dealt with the past sort of 7-8 months?
So with difficulty actually, but I mean, I have still kept on to the legal side to say I will always sign in front of the person who's written the will. I will always be witnessing, so we do it outside of the house. But legislation was passed in July because of COVID to say you can do remote witnessing, but it's got to be done again at the same time. So if there's a WhatsApp video call, both the witnesses must be watching, or on Zoom, both the witnesses must be watching at the same time, and you're watching the person sign the will. That will then comes back to the witness. They will then sign, and there's also got to be a particular attestation note left in the will to say this was done in these circumstances. And generally, if I was to do anything like that, I would do a recording of that if it's on Zoom or whatever, so that in the future, there's no issues. The dangers with all of that are, of course, undue influence, that kind of stuff. So we have to be careful, but the law has been passed, and that law will remain until the end of COVID.
Okay. And just a quick follow-up question on that as well, related to a valid will. I mean, where do you keep your will? So okay. I've done my will, where do I put it?
So we would always recommend storing the will externally, but ensuring your executors know where to get access to the will. We offer a storage service externally. So when we store it, the certificates, etc., will all go to the client, and they know they can get direct access, even if I've passed away. Storing it in your own house comes with its own dangers. Unless the executors know exactly where to go for that will, say if you have a burglary, you have a fire, whatever, only the original will can be used in probate. Okay, unless under exceptional circumstances the court allows a copy, which will then delay the probate process tremendously, because they need to give that time. They'll need to give inadequate timings in terms of making sure this was the last will you made. But really having the original will unaltered, undamaged, etc., is the key, because the probate office will just literally throw it back out if there's any kind of alteration, any kind of damage to the will. So storing it safely, securely is important. Okay.
Thank you.
So coming back to being of sound mind, it is said you've got to have a higher mental capacity to write a will than actually to get married. Think about it. Yeah. So you know your state of mind has got to be pretty good when you're doing the will writing. And like I said just now, wills must not be altered or damaged. Okay. So next slide, Joe. Okay, so just a couple of the points which Kaoru touched on. Wills should always be reviewed regularly, 5-6 years. Don't think that once you've written a will, that's it. You know, you're done with it. No, if circumstances change, you must change the will as well, if that's required, or at least review it. Mistakes will only come to light when it's too late, i.e., you've passed away. So you know it is important to ensure that the wills are reviewed and done professionally as well. I personally not a big believer of online wills unless you know exactly what you're doing. So these are very, very important legal documents. You know, give the importance they deserve and leave a legacy behind for your family, for your loved ones, rather than a mess. Because believe me, that mess can take years to clear up. So thank you on that. So we'll move on to the next slide. Okay, so I'm going to talk on about lasting powers of attorney, a vitally important document. Next slide, Joe. So lasting power of attorney is completely different to a will. It's to look after you while you're alive. Okay, so who are you going to give the power to make decisions in your best interest if your health has gone, i.e. due to loss of mental capacity, to an accident, something quite serious where you are no longer able to take your own decisions. Okay, next slide. So equally as important as wills, document is there, you're still alive, but what happens if you fall ill, you have an accident? I do a lot of power of attorneys, lasting powers of attorney, people who travel a lot, business people, simply, you know, elderly people who just physically cannot manage their finances but need help on other sides, etc. So very important. And the second point there, loss of capacity, dementia, again, all the figures indicate it's on the rise. And when you've lost capacity like that, you are in no man's land. We've got real issues at that point. So yeah, next slide. So there are two types of lasting powers of attorney. There's one for financial and property, which deals with anything to do with money side. So your home, your investments, property investments, anything like that, pensions, etc. And the other one is for health and welfare. If you've lost capacity, who will then be able to speak to the doctors, the nurses, etc. on your behalf? If you've lost capacity, imagine you've lost capacity, you have got no comprehension of what is going on, what people are telling you, what is right, what is wrong, etc. So you really need people you trust who can be there for you. Next slide. So the financial and property one, just like I've said, to do anything to do with money. The key difference between this and the health, financial one can be flexible, so it can be used as soon as it's registered, if that's what you want it to do with your permission, or we can state on there that it can only be used if you've lost mental capacity. Now, majority of the ones we do are flexible. People want to keep that, you know, you may have a car accident or whatever where you need help, even though your mind is perfectly fine. So it's better to keep it flexible. But many people want to keep that strict control until they've lost capacity or if they've lost capacity. So this is very much part of your financial planning. Yeah. Next slide. Health and welfare can only be used if you've lost capacity. Up to that point, doctors are asking you questions, nurses are asking you questions, you're able to answer them. So, you can still make your own decisions, but the day you can't, or if you can't, we need people who you trust to actually be there for you. Okay. So when you've lost capacity. Next slide, please. So key benefits of lasting powers of attorney, really I can summarize in one sentence, is to appoint people who you trust implicitly to take decisions in your best interest at all times. Absolutely vital is the trust element. There is someone there for you when you are no longer able to take your own decisions. Yeah. Next slide.
And Shandeep, just a very quick question on this because I'm conscious of time, but
yeah,
what happens, so we talk about mental capacity, but what if somebody is, I don't know, they have had a car accident, they're basically unable to speak because they're just unable to speak, so their brain's working, but their mouth's not, because, they might be asleep or something like that, and a decision has to be made on treatment for them. Does this lasting power of attorney overrule sort of next of kin type powers?
No. Generally, you would appoint your next of kin as the attorney anyway. So you are the donor making the power of attorney. The next of kin generally would be your attorney. If you're talking about temporary loss of capacity,
Yes.
i.e. you're in an induced coma or whatever, that power of attorney can be used because at that point you don't have mental capacity. But when you do regain your mental capacity, then you've regained that control back again.
Okay, yeah. Thank you.
Okay. If you do lose capacity, we don't have a power of attorney. It is too late. You cannot make a power of attorney when you've lost capacity. So basically the stage would be to apply to the court for a court of protection order, or a deputyship order where you are the deputy. It's a long process. It's an expensive process, and it comes with a lot of conditions. Particularly, they only generally give you on the financial side anyway, but the court will then put strict conditions, i.e. yearly reporting, what's gone in, what's gone out, how you've spent the money, all of that. Try and avoid that. Best practice for your financial planning as well as health planning, have the power of attorneys done. It's your insurance policy. I always compare this with your insurance policy. If something was to happen to you, bad timing, at least you've got this document there. Okay, next slide. So, Joe, if you can this really encapsulates everything I said. This is quite an old video, but it will give you an absolute taster for what a lasting power of attorney is, and it's very well made. So, yeah.
Sorry, Shandeep, I can't get this to play at the moment.
Okay, do you want to give me host and I can play to mine if you want?
Just bear with me.
That's typical, isn't it? We all tested it as well.
There you go.
6 years ago, Heather Bateman's husband, Michael, was knocked down on a country road.
I saw him 1 minute, the next minute I saw him, he was lying on the ground. An ambulance came and he never stood up or spoke again. It was the most horrific thing.
Michael fell into a coma. They'd been married for 28 years, and as the main breadwinner, his wages paid the household bills. Had you both made plans for the future?
We'd written our wills. I assumed that would be all I would need for the rest of our lives.
But as Michael was still alive, Heather discovered she wasn't allowed to use any of his money. Heather couldn't legally have access to Michael's accounts whilst he was ill because he hadn't granted her power of attorney over his finances before the accident. With that in place, she would have had complete control over all of his money. Instead, she had to apply to the Court of Protection. That is a court set up to protect the assets of vulnerable people. Heather finally got permission to manage her husband's finances, but with very strict conditions attached.
I could never write a cheque more than £500. Our daughter had just started university and the fees were over £1,000. So I was sort of being asked to ask permission to pay my own daughter's university fees.
The system was overhauled in 2007 in an attempt to deal with the issues raised by cases like Heather's. But since then, there have been so many complaints that the system is being reviewed once again. The Ministry of Justice told us that the changes in 2007 do allow a more personalised approach and give most people who deal with the court greater flexibility over how money is spent, whilst ensuring safeguards are in place for vulnerable people. The only way to avoid this additional heartache at such a difficult time is to appoint somebody as your lasting power of attorney. But despite the government's advice that everybody should do this, only 135,000 people in England and Wales registered one in the last 2 years. That is less than 1% of the population. Lawyer Julia Avery is an expert in this field.
Lasting powers of attorney are a document you put in place now so that the right kind of decisions, the decisions you've made for yourself, can be made by someone else for you at a time when you can't do it.
To grant somebody lasting power of attorney, you need to download the forms from the Office of the Public Guardian's website, fill it in, get somebody to witness it, and then pay £120 to register it. Or you could just pay a solicitor to do the whole lot for you. Having power of attorney could have saved Heather significant costs and a great deal of distress. After nearly 3 years in a coma, her husband Michael died.
I cried when Michael died, and I cried when I was released from the Court of Protection, that at last I was free. I wouldn't want anybody to go through that if they could avoid it.
So an interesting video, really shows, why you should have a lasting power of attorney. It is very old video, but it does give that message across really well in terms of lasting powers of attorney and what the consequences are if you don't. There's no timing on this about when you're going to fall ill, when you might have an accident, when you may have a stroke or whatever. So yeah, no, thank you for listening, and over to Tariq.
Thank you, Shandy. We've got a very, very quick poll that we wanted to put up for all of those that are listening in. So if you wouldn't mind, just a few seconds, just click on one of the 3 options there. How can we help? So help with either your will or lasting power of attorney, with help with inheritance tax planning, or actually would like a personal tax health check, which is sort of goes beyond the subject matter today. But click as many as you like, and give you a minute or so. And then we're going to go on to Q&A. So we've got a couple of questions. We have overrun a little bit, but I've got a couple of quick fire questions for our panelists, which I'm going to go through now. So I think this one's for you, Shandy. Does will cover assets wherever they are in the world?
So it depends on how you've written your will. Generally speaking, yes, most of our wills are worldwide, although professionally, we would always advise, if you've got assets, particularly property in different countries, like European countries, India, whatever, you should have a separate will made in those jurisdictions, because it could be tax favorable, but also the probate process is a lot quicker. So our advice is to have a separate will in countries where you have fixed assets like property.
And a will created in the UK, in England and Wales, is valid everywhere also. So in terms of getting probate in another country,
yes, you would need to reseal the probate in each of the different countries and follow their rules of succession.
Okay. And I did get involved once, actually assisting a client with probate in Greece, which was very, very, very difficult, incredibly difficult. So don't underestimate the complexity of it, and I think it's definitely worth getting local advice in those jurisdictions, as you say, Shandi. And also, just one very final question here: how wealthy should one be to have a will?
The will's not about how wealthy you are, etc. It's about doing the right thing and sorting out your affairs and making sure the loved ones behind you are not there to pick up the pieces. Of course, you know, if the circumstances are it's only you and wife, no one else, everything is going to go to the surviving spouse. But then what happens if you both die together? Where is it going to go? So it's not about wealth. It's about doing the right thing. It's about not being caught out under the law of intestacy and your assets going into the wrong hands.
Okay, and I've got just one question that's popped up, but let's see if we can answer it. Should be, well, I suppose that's how long a piece of string probably the answer. But the question is, how much does a will cost? And if it involves business assets, does this make it more expensive or complex?
Potentially, yes. I mean, you know, I can't give an off the cuff answer, but typically you're looking at anywhere between £300 and £600 for a will, depending on how complex it is in terms of trusts, if there's a BPR trust in there, if there's a discretionary trust, if there's a flexible life interest. It's all depending on circumstances. We work very much on fixed fee basis anyway, so you'd know right from the outset. However, if you have got business assets, if you've got a wealthy estate, paying 300, 400, 500 pounds, whatever, could save you, just in that spousal exemption, could save you hundreds of thousands of pounds of inheritance tax. That's the way you need to look at it.
Yeah, and obviously it saves a lot of hassle for your beneficiaries in the future as well.
Absolutely.
A lot more than £300, I'm sure.
Yes.
Okay, that's great. And sorry, just one other final question, which is on guardianship. So mother and father both pass away, and you've named somebody to look after your children.
Yeah.
Can that be challenged? Can you put anybody down? Are there
You can
rules
put
around?
anyone down. You can put absolutely anyone down. You've obviously got to get their permission when you've done the will. But yes, you can put anyone down as a guardian. No, it can't be challenged. It's your legal wish. It's been witnessed, and it's a legal wish. Yes, you know, if someone wants to take a challenge, of course they can. But no one generally cannot challenge a written document on that guardianship clause. No.
Excellent. Okay, well, listen, thank you everybody for joining. This is obviously a very complex area. I think we had a little bit of problem with sound early on. So do feel free to raise any questions either via email, or you can call our offices. We are offering a free 20-minute consultation on the tax-related matters. So if Kay is the person's contact, if his phone's busy, that's probably because lots of you are calling. But do reach out to him. And like I said, there's a free consultation there. Shandeep as well, I know he provides free introductory conversation as well about how he can help. We can find all our details on our website, and if there's anything else, like I said, that we can help you with, then feel free to shoot off an email to either myself, Kaya, or Shandeep. Thank you very much for joining. Thank you also for my panelists.
Thank you.
Thanks very much, Tariq.